All right, I only have 20 minutes within which to give my presentation, and there's a lot of things that I want to cover, but I just really want to thank Hint for having me out here. I was back, my first Hint summit was in 2017, and it's amazing to see how this crowd has really grown and the community that we have and the togetherness. I really feel like I've gotten to know everyone really, really well, given our bathroom situations. It's just amazing the closeness that we have. So anyway, all right. So we're going to start with legal issues when creating a network. First, some basic assumptions. We're going to assume that your organization is already a DPC practice, that you're not a hybrid practice, that everybody has opted out. That's super important. And that you're already experienced with employer groups, you're already serving employer groups. You're HIPAA compliant. I know that if you're direct to consumer and you are not sending protected health information electronically, you don't have to comply with HIPAA. But certainly if you're working with employer groups and so forth, I'm going to assume that you already are HIPAA compliant, both the security rule and the privacy rule, and that's super important. And that you're contemplating expansion by either opening up, bricks and mortar practices, which is super expensive and capital intensive, or you're thinking about expanding by affiliating with other existing DPC practices, either in your own state or out of state. So these are some basic assumptions going forward with my presentation. Okay, so the first question you're going to ask yourself is, given the states that you want to expand, do they have existing DPC statutes? And if the answer to that question is yes, then you want to make sure that your network provider membership agreements track the required language of the states that you want to expand into. And this is super important because you may be, compliant with your existing state, but if you're going to go into other states, you have to familiarize yourself with what their requirements are. And, I have a couple of examples here. Like in Kansas, the DPC statute there requires certain language at the top of the agreement in 10-point type. And if you aren't compliant with that, you're going to get in trouble with the insurance commissioners in that state. Same thing with Colorado. You need specific language containing regarding non-discrimination. Oregon, DPC practice needs to be certified by the Department of Consumer and Business Services, so on and so forth. If the state that you want to expand into does not have a DPC statute, and not all of them do, you can still go forward with expanding, but you have to make sure that your network agreement incorporates the consumer protections that exist in the statute in the states where DPC is legal. And you also have to make sure that you're complying with some of the other pronouncements. I know in the state of Maryland, they do not have a DPC statute, but for the practice that I provide legal help for in that state, we've come up with a way of being in compliance with the Maryland Insurance Administration's 2009 opinion, having limitations on what you can do. So what I'm saying is you can expand in other states that don't have DPC statutes. You just got to be very careful about how you go about doing that. Okay. The other thing that you want to make sure that you have is if you expand your network, you need to make sure that you have uniformity and compliance, okay? So if you are expanding by reaching out to another DPC provider, you need to make sure that whatever you provide as for your offerings is going to be consistent with what they're providing. So whatever services that you want to advertise as your network needs to be consistent with what that practice is doing. So if you're offering same-day appointments and you're basically advertising, whether it's direct to consumers or employers, that this is what you offer, you need to make sure that the affiliate is doing the same thing, okay? You also need to make sure that all your providers have, valid DEA license, valid license to practice medicine or they have professional liability insurance, all of those reps and warranties, you want to have that in your contract agreement with the affiliate. So you want to make sure you do your due diligence and you have your compliance. Same thing is that they're HIPAA compliant. And once again, if you've got a practice, a small DPC practice, who wants to become an affiliate because they want to have a larger patient panel, you need to make sure that they are HIPAA compliant with the privacy rule and not just the security rule. And once again, check out that if all of the status of your opted out doctors, make sure that they have their affidavits in order, okay? Next thing is, if you're going to be working with a DPC, or if you're working with an employer group that is self-insured and is working with a TPA, you want to make sure that you understand that your organization will probably be responsible for drafting a contract with that employer group. And the reason for that is because a third-party administrator probably has exclusive arrangements with primary care providers. So they don't want to hold the paper with your organization, all right? So they're going to want your organization to draft the contract and negotiate the contract with the employer group. And so you're going to be responsible for that. So you also need to understand that now your DPC practice or organization is not only bound under tort law, but also contractually with what they've agreed to provide to the employees of that organization. So you need to be mindful of that. So you're going to have not only, the standard typical tort law requirements, but also contractually you're going to be obligated. And you need to understand that. Also, the big thing is that you want to make sure if you're dealing with a self-insured employer, that self-insured employer is required under ERISA to have policies that are ERISA compliant, okay? So a lot of people understand that DPC is not insurance under state law. And that's how they've been able to pass the DPC statute, saying, hey, we're not regulated by the insurance commissioner, we're not insurance, so therefore, we don't have to be in compliance with that. The problem of it is that ERISA is a federal law. It is not a state law. So it doesn't matter what the states say about DPC. What matters is what ERISA and the federal law says. And ERISA covers benefits. It doesn't, so a pension plan is an ERISA benefit. So you might see, or have some concerns about the Department of Labor, which is enforcing the ERISA statutes. And you want to make sure that you don't get crosswise with the Department of Labor by not having an ERISA compliant practice, all right? So you have to be mindful of that. So one of the other things that you have to understand with ERISA is the process for COBRA continuation, and you have to understand how you, as a practice, are going to handle that responsibility, because you've got 12 months of continuation under COBRA. And so if you have an employee who onboards with your practice, and then the HR department tells them, hey, that person's no longer working, that individual is entitled to 12 months of continuation. So they're going to have to re-enroll on your platform, and you're going to need to make sure that when they get re-enrolled, they don't pay the consumer price, that they're paying the same employee-provided pricing. So it gets into a granular level on some of these things, but you just need to be aware of what your responsibilities are. Okay. If you are providing DPC to an employer who's not working with a TPA, you're still going to need to draft a contract with that organization, and you're going to have to make sure that you have certain language in your contract. And some of the things that are wise to have in that contract is that the employer needs to understand that you're not going to be the entity that's going to comply with some of the ERISA requirements. So you're not going to be preparing plan documents or employee disclosure notices. You're not going to be handling the 5500s. It's wise to have that in your contract with the employer, that is not something you're going to do. That's going to be up to them. And a lot of times with smaller employers, they don't even realize that they need to comply with this stuff. Okay, so let's move on to the corporate practice of medicine. How many of you have heard about the corporate practice of medicine, or CPOM? Okay. All right, so this is pretty important. So the corporate practice of medicine, it's a state law, and it's enforced by the AG and other court opinions, and it limits the practice of medicine to licensed people, licensed individuals. So doctors, they want to leave the doctoring to the practice of medicine to doctors and not to corporations. So there are over 33 states who have some form of corporate practice of medicine. And what you need to understand is whether you live in a state or practice in a state that has a weak prohibition against the corporate practice of medicine, or whether you are in a state that has a strong prohibition. Because this is going to, especially if you're in New York, California, North Carolina, or Texas, basically you cannot hire or employ a doctor, period. You may have an independent contractor arrangement with them, but you cannot hire them. And so this is very important, because if you're a management services organization, or if you have someone who is not a licensed healthcare provider in your organization, you might be violating the corporate practice of medicine. So how does the CPOM impact your DPC expansion plans? Like I said, if you have a DPC network that has a non-physician shareholder, and you live in a state that's either has a weak CPOM doctrine or it's non-existent as a statute, and you're going to be expanding into states that have a strong CPOM law, then you need to be concerned about not hiring physicians. And if you are going to hire them as independent contractors, that it makes sense under the IRS test, and that it is consistent with the attendant facts and circumstances in your case, all right? Also, generally speaking, your organization cannot engage in any type of fee-splitting arrangement with that physician. And we'll talk a little bit more about that later on. I know that California has in their Business and Professional Code, Section 650B, and this has been upheld by a 2015 Court of Appeals decision in the Plaquette case, where they said, you know, you can have this, where you can have a non-licensed individual who's a shareholder, and you can then engage in a percentage fee split in the way that you divvy up the money from the per employee or per member per month. Okay, fee splitting laws. All right, so fee splitting laws, it's a general prohibition against a doctor paying or receiving any type of remuneration, kickback, or rebate for the referral of patients, other than in a distribution of a healthcare organization revenues as permitted by law. So there's a very limited exception if you're a group practice and you're all practicing as a group, right? And you're dividing up the revenues according to the cost of overheads and so forth. That's a group practice. But if you're not in a group practice organization, then you have to be very, very mindful of what you're doing when it comes to fee splitting. All right. There's also the AMA Code of Medical Ethics and state legislation and the Medical Practices Act that has their own violations and prohibitions against fee splitting. All right. So be mindful of this when you're looking at expanding your network and being approached by other people who are trying to expand their network. Okay. Let's talk about the Florida Patient Brokering Act. This is super important. This is a relatively new piece of legislation that was passed as a result of the opioid crisis. And essentially, this is a criminal statute. And it prohibits any person, including providers, from receiving any form of remuneration or engaging in any type of fee splitting in exchange for referrals, regardless of the source of payment, unless there is an explicit exception. Your facts fit into the explicit exception of the statute. It's also a crime to aid or abet in any way in any type of formation. So you're even seeing lawyers getting in trouble for drafting agreements that aren't in compliance with the Florida Patient Brokering Act. So it's a first degree to third degree felony, depending upon the number of patients or the number the number of patients that you're fee splitting with or referring, $5,000 fine, as well as criminal repercussions. So how does fee splitting impact your DPC expansion plans? If your DPC network and expansion plan involves splitting the per member per month fee with another DPC practice, you need to rethink that plan. Because if you don't come under the group practice exception, the only way that you're legally going to be able to do this is if you use a flat fee. Super important, because you don't want to get in trouble with this or run amok of the statute. Okay, this brings up another subject about insurance brokers, and I think that you're going to see a lot of people moving into this space because they see how much it's expanding, and they want to be able to align DPC practitioners with employer groups. And you really have to be careful about what you're doing here. So once again, the Florida Patient Brokering Act and the Medical Practices Act contain exceptions when it comes to commission fees for that are lawfully paid to insurance brokers under the insurance code. The problem is that the DPC statute accepts DPC from the sale of insurance, and it specifically says it's not regulated by the insurance code. So a licensed insurance broker can't avail themselves of that exception and say, oh, well, I can go ahead and do this and get paid a commission because I'm a licensed insurance broker selling an insurance product. Well, if DPC is an insurance, then you're not selling a product. So make sure that any fees that are going to the brokers for the sale of this is coming from the employer groups, okay? And there's got to be full transparency between what the employer group agrees to pay you on a per employee basis and what you get paid. So if they want to get any fee whatsoever, it's got to come from the employer group and not from you. And that's all I've got. So if you have any more questions, please let me know. I'm sure you'll have my contact information. It's a lot to throw at you in 20 minutes, but I'm just hitting some of the high points. Thank you very much.